Good morning. Round two, fight. Brian B. posted this, and if you get a chance, take a look at Sheets v. City of Punta Gorda, Florida. Now, the first thing I normally do is I normally check to see what happened in the case. This is Pacer. This is for Sheets v. City of Punta Gorda, and you'll notice that it was voluntarily dismissed without prejudice. So what does any of the things in here mean? Well, they pretty much mean not a fucking lot. Except the only thing that they do mean is they give us insight on how the court would look at this case, what cases the court found to be on point, and how the court interpreted those cases and those rules of law. So what happened was Sheets filed a motion for a injunction, I believe. Preliminary injunction, yeah. So he filed a motion for a preliminary injunction, and the court denied the preliminary injunction. And that's what we're going to be looking at. We're going to be looking at the order denying the plaintiff's preliminary injunction. So remember, all that happened was a preliminary injunction was denied. So it's not a final holding on a case. It is there are standards that have to be met in order to get a preliminary injunction, and the court will go through some of those standards and will tell us where Sheets failed in that. But this is not a ruling on the merits of the case. It is not settled case law. You could draw a lot of inferences from it, but it's not settled, done. And just bear that in mind. There's a different standard. It's a higher standard, actually, that he'd have to hit to get the preliminary injunction than he would to prevail on the merits. So this is the, I'm not going to pay 15 cents a page or whatever they charge for downloading the order. So we're just going to look at this on Google Scholar. And so he went into a government building. He went into the city hall and he was recording. They had an ordinance that says that if somebody doesn't want you to record them, then they can tell you that they don't consent and you can no longer record them. You can record anything else in that building, but you can't record someone who tells you that they don't give you consent. You don't have to ask for consent, but if they tell you, I'm not consenting, then you can't film them anymore. So Sheets thinking, hey, I'm in a public place. This is a government building. My tax dollars at work. I have a First Amendment right to do this. He goes in there swinging, right? So this is the legal standard that he has to meet. He has to have a substantial likelihood of success on the merits. That's step number one. He didn't win on that point. Step number two is irreparable injury will be suffered unless the injunction issues. He failed on that point as well. Now, if he had won on the irreparable injury, if the court found that there would be an irreparable injury, it might change the equation. The court might look more favorably on the likelihood of success on the merits. There is a bit of a balancing that always goes on because people are people. And the threatened injury to the movement outweighs whatever damage the proposed injunction would cause the opposing party. Again, he failed on that point. And if issued, the injunction would not be adverse to the public interest. So he doesn't do very well. But again, what's interesting is the analysis the court goes through to give all of you folks out there in La La Land who think that you can record whenever, wherever, and whyever you want, the First Amendment may not protect you. So I guess we'll just start reading. The First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. Sounds good for him so far, right? Like all First Amendment protections, this right is subject to reasonable time, place, and manner restrictions. Whoop, it's going off the rails here. This looks like a forum test, right? Here, the court assumes without deciding that Sheets had a First Amendment right to record city employees while they worked in City Hall because the city does not argue otherwise. What the court is saying that even if I look at this fact, even if I decide this fact or this standard of law, I should say, even if I decide the law in your favor in this, you're still fucked. So that's why the court assumes without deciding, because Sheets is just on a losing trajectory in this request for a preliminary injunction. And I believe that the issue behind this preliminary injunction is Sheets went back and did it again after getting the ticket for it the first time. Having concluded Sheets had a First Amendment right, the court must determine the scope of that right. There are limits. That's what the court's saying, is there are limits. It is by now clear that the First Amendment does not guarantee access to property just because it is owned by the government. That's a bad start, right? Instead, courts use forum analysis to evaluate governmental or government restrictions on purely private speech that occurs on government property. I can remember fondly the days of yore where people would say, oh, that Murby's, he just does forum analysis. That's all I could think of is forum analysis. I mean, he's just so limited. He just doesn't understand the bigger picture. He just talks about forum analysis all the time. There are several different forums. One type is a limited public forum. Here, the parties agree City Hall is a limited public forum. But see also the Punta Gorda Code designating the City Hall as a limited public forum. They don't have to make it a limited public forum. The parties just agreed to this, and Punta Gorda's municipal code designated City Hall as a limited public forum. So don't go charging into every City Hall saying this is a limited public forum because of Sheets versus the city of Punta Gorda. I just want to caution you on that. This distinction matters because the type of forum determines the level of scrutiny applied. Ordinances regulating speech in limited public forums are not subject to strict scrutiny. This forum exists where the government has reserved it for certain groups or for the discussion of certain topics. So a limited forum is not open to the public at large for discussion of any and all topics, and it can be set up to grant only selective access to the class for which it is reserved. For that reason, regulating a limited public forum need not be content neutral. Instead, restrictions on a limited public forum need only be number one, reasonable, and number two, viewpoint neutral. It's the exact same test as the non-public forum. Reasonable, viewpoint neutral. Here, Sheets did not carry his burden to show the ordinance is unreasonable or viewpoint discriminatory. So for those of you who think that an ordinance requiring someone to or requiring you to stop filming if someone revokes their consent or says that they don't want you to film them. I mean, just so you know, this court is telegraphing its initial thoughts on the subject. It's not the final thoughts. There would be more briefing on all of this stuff throughout the remainder. You know, you'd have a trial brief, you'd have the actual trial itself with arguments and things like that. So don't read too much into it. Thus, he's not entitled to the extraordinary and drastic remedy of a preliminary injunction that enjoins a municipal ordinance before a trial. So it's now going to examine the reasonableness standard. To survive a First Amendment challenge, the ordinance must be reasonable. Now, again, they're looking at this in the terms of a limited public forum test. It has to be reasonable and viewpoint neutral. That's why they're looking at reasonableness. Some forums have a higher requirement than just reasonableness. Reasonableness must be assessed in the light of the purpose of the forum and all the surrounding circumstances. Because the government chooses how wide to swing open the gate of a limited public forum, it may allow access only to certain speakers based on their identity. So a speaker may be excluded if he's not a member of the class of speakers for whose essential benefit the forum was created. Importantly, a restriction need not be the most reasonable or the only reasonable limitation to withstand a constitutional challenge. So you saying, well, they could do it better isn't an argument. It is what they're doing reasonable? Doesn't matter how much better you could design the system, it is whether or not what they are doing is reasonable. The government, like any private landowner, may preserve the property under its control for the use to which it is lawfully dedicated. This is the exact language out of Adderley v. Florida, but they're just quoting it from a newer case. Internal quotation marks and citation omitted. That would be to Adderley v. Florida. Likewise, a government workplace, like any place of employment, exists to accomplish the business of the employer. It follows that the government has the right to exercise control over access to the government workplace in order to avoid interruptions to the performance of the duties of its employees. So if you go in there and just by filming, you are interrupting the performance of the duties of its employees, the government, in a limited public forum or a non-public forum, has the right to exercise control over your access. They can kick you the fuck out, all other things being equal. Based on the preliminary injunction record, the ordinance places reasonable restrictions on recording at City Hall, given its purpose and context. The purpose of City Hall is to conduct legitimate public business. And walking in there saying, well, my business is recording public employees. No, it is the City Hall's legitimate public business. And the ordinance restricts recording within City Hall without the consent of those being recorded. If someone violates the ordinance and refuses to stop recording, the city considers that person a disruption of city business. According to the city's affidavits, prior unconsented recording created disruptions for employees conducting city business. Imagine that. Videos of several city employees circulated on the internet, leading to death threats, suspicious packages in the mail, and so many threatening calls that the city had to shut down its phone lines. Imagine that! Nor does this ordinance... So for those of you who think that call floods and this kind of bullshit work, what the call floods did is it got a new ordinance passed that further limited your ability to record. Congratulations. Nor does the ordinance completely exclude Sheets or anyone else from City Hall. Sheets can record in any public part of City Hall if he is not recording a person who does not consent. Considering this evidence, a court cannot say a restriction on unconsented recording is unreasonable considering City Hall purpose and these circumstances. So they're looking at what has happened in the past when City Hall didn't limit photography. It created havoc. So it's reasonable considering the circumstances. Stating the government need not wait until havoc is wreaked on its workplace to restrict access to a non-public forum. Ta-da! And so they slipped here into a non-public forum. Remember, we're talking about a limited public forum, but a limited public forum is basically a non-public forum that the government has opened a little bit to some speech. And it can control that speech. It's basically a non-public forum. The test is the same as a non-public forum. As the Supreme Court noted, restrictions on limited public forums need not be the most reasonable or the only reasonable limitation to survive a legal challenge. Still, says Sheets, the ordinance is unreasonable because it does not limit the time someone may be barred from City Hall. So, as the argument goes, the ordinance allows law enforcement to expel violators for unlimited lengths of time. Yet the ordinance simply empowers city employees to ask the police to issue a trespass warning. Nothing in the ordinance signifies that city employees control the duration of the trespass warning. Further, Sheets' ban is limited in time, 1 year, and geographic scope, City Hall and the Annex. I'm guessing here that that means that this court sees no issue with trespassing someone from a city hall. Weighed against the city's evidence, Sheets offers no legal support for saying this limited restriction is unreasonable, nor has Sheets pointed to a single instance in which the city issued open-ended bans from government property. Sheets also asserts the ordinance is unreasonable because City Hall has surveillance cameras, so the city is disrupting business with unconsented recording. Where have we heard that argument before? Yet the ordinance exempts law enforcement activities. Punta Gorda Code, Section 15-48E. And using security cameras in a government building is almost undoubtedly a law enforcement activity. In any event, without more, the city using security cameras would not open the limited public forum to unconsented recording by visitors. It's their forum. They get to pick who gets to talk and how much. And the city can talk all at once. The city can do on its own property what it wants with security cameras. Thus, the court determines Sheets fails to carry his burden on reasonableness. And before somebody says, like, does that mean that they could put security cameras under the toilet seat so they can record people pooping? No. You get my point, though. I mean, obviously in a bathroom that'd be wrong, but I mean, like, using security cameras for the normal purpose of using security cameras, the city can do that without issue. Viewpoint neutral. Now remember, viewpoint neutral is the second part of the test. It has to be reasonable, and viewpoint neutral. Reasonable, viewpoint neutral. We just did reasonableness. Now we're looking at viewpoint neutral. Second, Sheets did not show that the ordinance is viewpoint discriminatory. A restriction on speech constitutes viewpoint discrimination when the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the restriction. Viewpoint and content discrimination are separate but related concepts. Content-based regulations target specific subject matter regardless of whether they discriminate among viewpoints within that subject matter. Whereas viewpoint discrimination is an egregious form of content discrimination because it targets not subject matter, but particular views taken by speakers on a subject. For example, a law banning the use of soundtracks for political speech and only political speech would be a content-based regulation, even if it imposes no limits on the political viewpoints that could be expressed. So the content would be political speech. A viewpoint discrimination would be like, it only bans the use of soundtracks for pro-Republican speech, or it only bans the use of soundtracks for pro-Democratic political speech. That would be a viewpoint restriction, which would be a violation. Here, the ordinance is facially viewpoint neutral because it does not target any viewpoint, ideology, or opinion. Rather, it regulates the conduct of all City Hall visitors equally without regard to viewpoint. Put another way, the ordinance applies the same to everyone, no matter why they show up at City Hall with a camera. Unconsented recording and the refusal to stop is defined as a disruption of city business under the scheme. But that does not mean, as Sheets suggests, it targets viewpoint. To circumvent its viewpoint neutrality, Sheets contends the ordinance poses a risk of viewpoint discrimination because it does not constrain city employees' ability to withhold consent to be recorded. That is where the unbridled or unfettered discretion doctrine comes in. It is long settled that when a licensing statute allegedly vests unbridled discretion in a government official over whether to permit or deny expressive activity, one who is subject to the law may challenge it facially. Maybe the plainest example of an unconstitutional grant of unbridled discretion is a law that gives a government official power to grant permits, but that provides no standard by which the official's decision must be guided. In that case, the official can grant or deny a permit for any reason she wishes. There are several problems with Sheets' unbridled discretion theory. The most glaring is the standard for preliminary junctions, and Sheets has not pointed to a single case applying this doctrine to a similar speech restriction. Some others follow. What she's saying there is that no one has ever used a unbridled discretion challenge to get a preliminary injunction based on a facial challenge. First, Sheets says the city conceded that the purpose of the ordinance was to grant city employees with unbridled discretion to restrict recording. As the city notes, this is an inaccurate characterization of the briefing. Rather, the ordinance seeks to prevent disruptions of the city's legitimate public business and rendering public services, along with fostering a safe and orderly environment. As discussed, the ordinance is a reasonable restriction to fulfill that purpose, and Sheets presented no evidence to make the court question that purpose. Neither party located any cases directly on point, but the court found one somewhat helpful. In U.S. v. Geleno, a court considered whether an audio and video recording ban was unconstitutionally overbroad. There, Geleno went to a federal courthouse with a video camera to film a public meeting of a local police oversight commission. This was in California. When Geleno tried to bring his camera inside, court security officers, CSOs, stopped him from doing so. No court was in session that day. The courthouse had a policy allowing cell phones and computers, but prohibiting their use for taking pictures and recording sound or video without approval. Geleno argued the CSOs had unfettered discretion under the policy to prevent recording of public meetings. The court disagreed, holding that CSOs did not have or exercise unfettered discretion because they needed to ensure the safety and privacy of both the judges and staff and make sure they were not photographed or filmed without their consent. As described below, the ordinance allows far more recording and far less discretion than Geleno. This ameliorates the risk of unconstitutional viewpoint discrimination. Second, any discretion individuals have to prevent recording is necessarily limited. Under the ordinance, people can only withhold their own consent for recording of themselves. Put another way, no one can withhold consent to record anyone else, nor can a person prevent recording of City Hall's public areas. So while the ordinance does not delineate standards to guide withholding consent, any vested discretion is not unbridled or unfettered. Rather, it is personal and limited to each individual. Here, for instance, Sheets recorded the lobby of the City Hall before encountering anyone. Under the ordinance, no city employee could prevent him from doing that. Similarly, if Sheets had consent to interview someone, a city official could not prevent him from doing so. This limitation on consent ensures no person, city employee or otherwise, can completely prevent First Amendment activity. Thus, Sheets failed to show the ordinance grants unbridled discretion sufficient to justify a preliminary injunction. Interesting, and this is interestingly, the ordinance likely allows more speech than necessary. I'm going to let that sink in. Interestingly, the ordinance likely allows more speech than necessary. It doesn't necessarily, but it likely allows more speech than necessary. For instance, if the ordinance simply prevented all recording, it would probably be reasonable for the reasons described above, and there would be no discretion to analyze. So the court would simply decide whether the restriction was viewpoint neutral. And then they cite to a case. Even so, the court cannot conclude Sheets clearly showed he's entitled to relief simply because the ordinance allows more speech by allowing consented recording. In Blodorn, a public university prohibited outside speakers in a limited public forum on its campus. Yet the university allowed outside speakers the opportunity for speech in the forum if they were sponsored by the university or one of its groups. So, like here, the speech policy in Blodorn allowed more speech if the speaker obtained the sponsorship, i.e. consent, of the school or a school group. Still, that scheme was reasonable and viewpoint neutral. The 11th Circuit considered this alternative avenue for speech as a basis to justify its conclusion that plaintiff failed to establish a substantial likelihood of success on the merits of a preliminary injunction request. So they were looking at it, that one again, that was requesting a preliminary injunction. Third, the ordinance is not licensing or permitting scheme that allows city officials with discretion to allow or disallow speech. Instead, it simply penalizes unconsented recording that becomes a disruption of city business after the person refuses to stop. To the extent that the ordinance grants discretion, it vests any person, including government employees and even Sheets, with the power to withhold consent or to record them inside City Hall. All the same, says Sheets, because government employees are among the people who can withhold consent, they have unbridled discretion. Sheets cannot cite a single case that supports this theory. This is likely because the doctrine typically applies in a very different context, one where one or more government officials have unbridled discretion to license or permit speech. First Amendment concerns are inherent in such a scenario because the officials are left with unchecked power to engage in viewpoint discrimination. What those cases do not address is a situation in which everyone, including plaintiff, merely has the power to withhold their own consent. While not discussed by the parties, the court located one case relevant on this point. In Bell v. City of Winter Park, Florida, the 11th Circuit held an ordinance granted unfettered discretion for private citizens to prohibit speech. Bell, however, differs. There, the forum was a traditional public forum, which enjoyed a much higher level of protection than limited public forums. What is more, the ordinance in Bell enabled citizens to prohibit speech entirely, like a typical unbridled discretion case. But the power to withhold consent here is far more limited. So apparently in Bell v. City of Winter Park, the citizens were allowed to say, you can't record at all in this park. And different forum and different power. Finally, there is a question of whether the ordinance is a prior restraint at all. A prior restraint is an expression, or a prior restraint on expression exists when the government can deny access to a forum for expression before the expression occurs. Here, anyone can enter City Hall and record a non-consenting person without punishment or exclusion. So the ordinance appears to be a subsequent punishment, which regulates a given type of speech by penalizing the speech only after it occurs. The 11th Circuit left open the question of if the expression of if the unbridled discretion doctrine could somehow be applied beyond the context of prior restraints. Sheets argued that the ordinance is a prior restraint because it prohibits recording unless and until consent is given. The city disagrees, so does the court. The ordinance does not penalize unconsented recording. Instead, it penalizes the subsequent refusals to stop recording without consent or leave City Hall because they disrupt the purpose of the forum. So in short, he failed to carry his significant burden for the extraordinary and drastic remedy he seeks on the First Amendment claim. And then we have the 14th Amendment claim. Next, he brings a procedural due process claim under the 14th Amendment, challenging the ordinance facially and as applied, and neither the pleadings nor the briefing differentiate between the two. To pursue a procedural due process claim, a plaintiff must show 1, a deprivation of a constitutionally protected liberty or property interest, 2, state action, and 3, constitutionally inadequate process. Only the first prong needs analysis because Sheets does not show substantial likelihood of success on the merits, so they did not continue on. Plaintiffs have a constitutionally protected liberty interest to be in parks or other city lands of their choosing that are open to the public generally. This right likely extends to City Hall. That right, of course, is not absolute. For example, there is no constitutional right to use public parks under all conditions and all times. And a person may forfeit this liberty right by trespass or other violation of law. Under the plain language of the ordinance, when a person refuses to stop recording without consent, that person is a disruption and no longer at City Hall on legitimate city business. If, after being asked to leave, the person refuses, then the ordinance considers the person to be a trespasser. So the person forfeits any liberty interest in visiting City Hall, and the city can restrict access to City Hall without impacting constitutionally protected liberty interests. Sheets makes no argument for how a person has a liberty interest to visit City Hall under these circumstances. Despite City Hall being a government building, the public has no constitutional right to visit City Hall under all conditions and at all times. The government can control its property for the purpose to which it is lawfully dedicated. So it seems equally clear that the city can exclude trespassers and people causing disruptions within a geographic and time-limited trespass warning without violating a protected liberty interest. While Sheets relies on Catron, that case is distinguishable for 2 reasons. First, in Catron, several homeless plaintiffs received trespass warnings for being in a public park. The 11th Circuit clarified plaintiffs there were not trespassing when they were given trespass warnings, whereas here the ordinance only allows for trespass warnings after a person is disrupting city business and trespassing. Second, because City Hall is open to the public, like the park in Catron, Sheets claims a protected liberty interest to visit City Hall. Where have we seen that before? Sheets argues he only needs to identify that liberty interest, yet he is mistaken. Plaintiffs must show not only a constitutionally protected liberty interest, but also a governmental deprivation of the constitutionally protected liberty interest. The deprivation portion of that element is where Sheets drops his burden, because if a person forfeits the liberty interest, then there has been no deprivation. People recording without consent are not using City Hall under ordinary conditions or for its intended purpose. The park in Catron was open to the public generally, and the trespass ordinance prevented plaintiffs' ordinary use of the park. The 11th Circuit stated that the due process rights at issue were to use the parks under the ordinary conditions in which those parks are made available to the general public. That's important. So you could use it under the ordinary conditions in which these parks are made available to the general public. That's your due process issue, or your liberty interest. While Sheets is correct, City Hall is open to the public, he ignores that it is open to the public to conduct legitimate city business. They keep using that word, legitimate city business. You might take a note of that. And the city may limit the use of the property to ordinary conditions for its intended purpose. And then lots of examples. Put simply, neither Sheets nor any other person has an absolute right to visit City Hall. So when the city limits the use of City Hall based on a violation of the ordinance, it is not violating liberty interests. At the hearing, Sheets argued he violated the ordinance on purpose because he believes it is unconstitutional, and he wanted a pre-deprivation hearing to argue to that effect. But neither a pre nor post-deprivation hearing was necessary because Sheets forfeited his liberty interest before the deprivation. And the remedy he seeks to invalidate the ordinance was available in court all along. Remember I told you you didn't have to get arrested in order to challenge ordinances like this in court? At any time, Sheets could have brought a First Amendment unbridled discretion challenge to the ordinance without violating it. So the argument Sheets was denied due process to challenge the ordinance falls flat. While not dispositive, the court notes the city's argument on factual matters over Sheets' residency. That doesn't really matter. Sheets may not have been a citizen. So anyway, take that again with a grain of salt. This is an order denying a preliminary injunction. It is not a final ruling on the merits, and there is a higher standard required to meet in order to get a preliminary injunction. But it is very interesting, the analysis the court used, and I hope you enjoyed it. Thanks for watching. Have a great day.